time requested, so I only ask for the time that you need, not the time you wish. We are familiar with the briefs and the records, and if we have further questions, we will keep asking them after the time runs out. People versus Yamil Vega, appellant? Respondent?
Respondent
5, 1, and 5. Ferrer versus Go New York Tours, appellant?
Appellant 5 and 2.
Respondent? 5, 2, and 6. TL Children is submitted. Smith versus City of New York, appellant?
Appellant City of New York, 5-1.
Respondent?
Respondent
5, 1, and 5. Petit versus Bronx Neighborhood, appellant?
Yes.
How much time are you requesting?
5.
Respondent?
3.
5, 1, and 3. Parella Weinberg Partners versus Kramer, appellant?
7-2, Your Honors.
Respondent? 7, 2, and 7. Downey versus Giles, appellant?
Good afternoon, appellant. Requesting 5 and 1.
Respondent? 5, 1, and 5. People versus Kevin Hall is submitted. Flintlock Construction versus HPH Services, appellant?
For appellant 5 and 1.
Respondent?
6, Your Honor.
Do you want rebuttal time since you have a cross appeal? So I'll give you
2, please.
I give you each 5 and 1. Javari versus FSP 787-7. Are you New Deal?
Appellant Respondent
New Land.
We'll take 5 and 1.
Okay. Defendants? Okay, Eurotech? No, I know you are. I'm going on to the next person. I'll give you all your times when we're done. Eurotech? And plaintiff?
4 minutes.
Okay, 5, 1, 6, 1, 4, and 4. Traore versus City of New York, appellant? Submitted. People versus Hillary? Submitted. Joswick versus Monair is submitted, and Good Logic versus Merchant is submitted. People versus Yamil.
May I begin?
Yes.
Okay. Good afternoon. Benjamin Rutkin-Becker from the Center for Appellate Litigation on behalf of Yamil Vega. This court should reduce the post-release supervision component of Mr. Vega's sentence by 6 months, or at a minimum, order a resentencing to remedy the right to counsel violation. Beginning with the sentence.
Before we go into that, do you want to address the waiver of the right to appeal, since that, if enforceable, would foreclose your claims?
Sure, Your Honor. So to begin, there's 2 background considerations that should inform this court's analysis of the waiver in its totality, and then there are 3 specific issues with the waiver. So in terms of those 2 background considerations, one, this is Mr. Vega's first ever experience with the criminal system. He's never even taken a plea before, and as Your Honors are well aware, this is a long colloquy with a lot of information that for someone in Mr. Vega's position, he's also only 20 years old, has some education, high school diploma, but again, young, his first experience. So this needs to be a very precise waiver. Secondly, the timing of this waiver was after Mr. Vega has already allocated and admitted his guilt to the offense. I think anyone in that position would have a very difficult time understanding that they are still free to go backwards after they've admitted guilt, especially someone who's never been through the system before. This court in Castillo and another case has recently
It
held.
sounds though like it's somewhat discretionary whether a waiver appeal is valid or not. Isn't there certain standards you need to meet to show that it's not a valid waiver?
Of course, Your Honor. So that goes to the three specific mistakes with the waiver. I just wanted to ground the waiver with that context to begin with. Again, in terms of the timing of the waiver, this court has recently held that it's better practice not for the waiver to occur in that, and has upheld a waiver that was otherwise, quote, clear and comprehensive. So that's all to say this needed to be a really good waiver, and it was not. One,
I mean, other than the timing sequence, which you mentioned, what else in this particular waiver was not up to par in your opinion?
Sure, Your Honor. So one, this differed from the CJI in a meaningful respect. The CJI carefully has the first thing after the Boykin rights that the court should explain to be that ordinarily the right to appeal is retained, it's separate. Here the court immediately pivoted from the Boykin rights to saying you're also waiving your right to appeal. That's confusing. It seems as if the right to appeal is a part of the plea. Secondly, the court, when initially explaining the right to appeal, said that normally that would include the right to counsel, attendant with the right to appeal. But then when explaining the waiver and what survives, the court only mentions that Mr. Vega could still file a notice of appeal. I think it's confusing from that he would still retain the right to counsel. And third, the court never explains the distinction between legality and excessiveness of a sentence, which for someone who's never been through the system before would be confusing. So for all those reasons, the waiver is invalid.
Do you want to address the reduction while there's still some
Of course, Your Honor. So this is an unusual excessive sentencing case in that this court can benefit from a fuller record than was before the sentencing court. What we have here is an individual who's 20 years old. This is his first arrest. He's an active father and caretaker to two very young children. He has such an active support system that even the sentencing court found that notable. And he was out on bail, as the prosecution points out. We don't contest that. But he was excelling in an alternative to incarceration programming. He was engaging.
The only issue at this point is whether or not we reduce the PSR the PRS, sorry. Given that he waved a loaded gun at a person, I think there would be good reason for us to defer to the trial court's view that he needed this much time in supervision, right?
No, Your Honor, and for all the factors that I already mentioned about my client's background, you will not find any justification from what happened from us. This was clearly a very bad, impulsive decision. There's no getting around that. But this was a case that was on a certain track. This was the worst decision that my client has ever made. His only interaction with the system. And he immediately joined cases programming. He was doing great.
What would be inappropriate? I think she's asking to have a little more supervision of him for another 6 months then. It's not an incarceratory provision we're talking about. It's just being supervised.
This is not.
As you said, it was quite impulsive.
There are individuals who can benefit from increased supervision. This is not that case. This was a one-off decision. Mr. Vega has served 2 years. If it were not for, he was doing very well in the community until a rearrest on New Jersey charges that have since been dismissed. This court should consider that. This case could have gone and likely would have gone entirely differently. The prosecution cannot debate, and it would be just defy common sense for them to debate that this rearrest affected the trajectory of this case. He was remanded after.
You're going to have time rebuttal. Thank you.
Thank you.
Good afternoon, Your Honors. Amir Kedmati for the people.
So what appropriate penological purpose would be served by his serving the additional 6 months of supervision?
Well, Your Honor, as far as the sentence the defendant received, if I may, the defendant is trying to really set the theme that this person was never going to receive jail time, and it was only because of these Jersey charges that were later dismissed that people considered jail time, and now they're saying that this post-release supervision term that he's now currently under serving is somehow infringing, infringing, it's perhaps too much of a punishment for him. Really, Your Honor, there is nothing in the record that suggests he was never going to receive jail time. This is not a simple gun possession case. In fact, he used the gun, a loaded gun, to menace an MTA bus driver.
You're not addressing my question, which is
Yes, Your Honor.
what valid penological purpose would be served by an additional 6 months of supervision at this time?
Well, Your Honor, we believe
I'm
that...
not asking you to go back in time. I'm asking you to go
understand.
forward.
You understand, Your Honor. We believe that the post-release supervision, that term that he received, was minimal, and it's for the defendant's benefit first and foremost, and it also benefits the society because this defendant did act in a reckless way toward an MTA bus driver, and the employees of the MTA, there's been rising crimes against them, and he was an on-duty bus driver at the time when this incident took place, and we believe that this defendant benefits from further supervision. And there's also the Less is More Act. So if he actually conducts himself without committing any parole violations, he's going to be able to benefit from good time credit
Do you know
in that way as well.
how far along he is into that 2-year sentence, post the PRS? Do you know
I
how
believe,
far
Your Honor,
along he
there
is?
is the maximum expiration date for his post-release supervision term is May 2nd of 2025.
Okay.
But most likely, as long as he doesn't commit any parole violations, he's going to complete that sentence within the next few months, I would imagine.
Thank you.
And if I may, just a few comments about the appeal waiver. The appeal waiver in this case was pretty much nearly perfect. There were really no issues with it. Defendant, the record clearly establishes that defendant knowingly and voluntarily waived his right to appeal. The oral colloquy was perfect. In fact, Justice Lorenzo separated defendant's trial rights from his appellate rights by using the language articulated in People v. Lopez, separate and apart from them. The court went on to tell defendant exactly that he's going to forfeit most claims of error, including excessiveness of sentence, which is one of his claims on appeal. All 5 of them, by the way, are waived by his appellate waiver, and I've articulated or referenced the specific cases authority that establishes that. And also, it was done in consultation with counsel, and defendant also signed a detailed written waiver. And lastly, as far as the decision in People v. Castillo, which this court, I believe, in about a month ago, on April 24th, recommended that it's better practice for the plea allocution to be conducted at the end. I agree with that as well. And however, I think what the court was really trying to do in that context with that recommendation was to make sure defendants, before pleading to the actual conduct that they do, have an understanding of the appeal waiver or whatever it is that they're promising to. Here, that basically already happened because it was clear from the record at the outset, defendant, the appeal waiver was part of the offer. Defendant was aware of it. Counsel communicated that to the court. And in fact, the written waiver was already executed. And so in that way, defendant had an understanding of what he was agreeing to. It wasn't like he allocated to the crime and then all of a sudden the prosecutor was like, oh, now we're asking you to waive your right to appeal as well. So that really addresses that issue as well. I did plan on making a few comments about defendant's request for new counsel as well. I just wanted to say that when we look at the record in its totality, Justice Lorenzo exercised sound discretion when defendant made multiple requests for new counsel. The second time, and this happened on multiple dates, on a Wade hearing, on the day that a Wade hearing and possibly trial was scheduled, 15 months after he was being represented by his first retained counsel, who represented him very well. He engaged in motion practice, discovery, and he even secured the offer that the defendant ultimately accepted. And
did he make any specific allegations, complaints with regard to seeking new counsel?
Your Honor, you're referring to specifically to the proceeding that occurred on April 28th, 2022. In that appearance, defendant appeared in front of Justice Lorenzo with his counsel. Defense counsel did not really make an application to be relieved. He said, my client is dissatisfied with my performance. I already explained to him that Your Honor recently appointed a new attorney, and it's unlikely that you're going to give him a new attorney. And at that point, Justice Lorenzo, this is about a month after he had already granted defendant's first request for new counsel, because previously the defendant complained that his attorney is asking for money, and Justice Lorenzo said, well, that's what happens when you retain your own attorney. Regardless, Justice Lorenzo gave him a new attorney. On that specific proceeding with Jeff Henley, his appointed counsel, Defense counsel made the comment that I just alluded to, and then Justice Lorenzo said, well, this case is on for a hearing. And the defendant said, but we have not been in communication. To the extent that defendant's comment, defendant alleges that it was serious or specific, which is what the case law requires for the court to be, for the court's obligation to conduct a minimal inquiry to be triggered, we don't believe that was the case because on its face, it was not true that they were not in communication. First of all, he had told his counsel he's dissatisfied with him, so they were in communication. And secondly, defendant and his attorney had appeared in front of Justice Lorenzo on 2 previous occasions. And the ultimate goal of Justice Lorenzo was to ensure that defendant benefits from intelligent and adequate representation. My apologies.
No apologies, but I think you've answered our question.
Thank
very,
you. I asked
very
the honors
amply,
to
so
it.
thank you.
Thank you so much.
Okay, I'll be very quick on the sentence because I would also like to briefly address the resentencing issue. The simplest and fairest way to resolve this case we submit is the 6-month reduction. 2 years incarceration is already quite a serious intervention for someone who made, again, a terribly impulsive decision that is anomalous from every other thing we have in this record. It is unfortunate, but the realities of the appellate process, that this appeal, it's taken quite a while. Of no fault of Mr. Vega's, it is now being argued after he's been released, but less is more is not a reason to deny him this modest relief, which can send a very powerful signal to him that this court, this system believes in his rehabilitative potential, and he does have tremendous rehabilitative potential. To pivot quickly to the right to counsel violation here,
You have 5 seconds left. so
okay,
it's gonna have to be a very quick
thank you.
pivot.
What's most telling to me about the prosecution's argument is the prosecutor says absolutely nothing about the second request made to Justice Barrett, where counsel affirmatively asked to be relieved and stated that there had been a breakdown in communication earlier that day. That was not the same request that was made before Justice Lorenzo. Justice Barrett could have simply asked whether it was the same request. Either of these 2 judges could have asked a single question.
Thank you. And
Neither did, and
we
they
have
were
the
required
briefs in the record
Thank
and
you.
are familiar with the case, so we will look at it. Thank you very much. Ferrer versus Go New York Tours.
Good afternoon, Your Honors. May it please the court, I'm Maurice Ross on behalf of Go New York Tours. The motion court made 2 fundamental errors of law. First, this court has written, and I'm quoting, "The law is clear that loss of enjoyment of life is not a separate element of damages deserving of a distinct award, but only a factor to be considered by the jury in assessing damages for conscious pain and suffering." That's from the Flores case, which we cited. That's consistent with Court of Appeals teaching in the McDougall case. This court, what the court has done is defy those categories, those statements of law. And what it did in denying...
Didn't the plaintiff indicate that he was not looking for any damages and would not be looking for any damages before the jury for loss of enjoyment of life? He's just looking for pain and suffering. You're right that very often they're incorporated. They would be incorporated, but if he's not looking for them, the court won't charge them. They won't hear that testimony.
Well, yes, except that if you look closely at the brief on appeal, plaintiff is seeking damages for emotional damages, psychological damages. And the Court of Appeals and this court has made clear that you can't really separate out. Once you're seeking damages that involve emotions, the issue of effect on enjoyment of life is inextricably intertwined. But more importantly, the defendant has the right to present evidence on that issue, one way or the other.
Why do you have a right to present evidence on that issue if the plaintiff isn't seeking it?
Because if plaintiff puts on an expert that testifies about the emotional consequence of this injury, the suffering, that the response is an expert who does a forensic analysis of the lifestyle of this individual, whether it's affected his ability to play sports, whether it's affected his ability
But if
to...
he's not putting in any claim that he can't play the sports or that he can't do those things, and he has explicitly withdrawn those claims, then why would you be entitled to rebut something he's not even trying to establish?
Because-
He's just saying, All he's asking the jury to say is, because I had this injury, I will have some pain and suffering, and the jury can assess what that injury is and decide whether there's pain and suffering associated with having that type of injury.
But, Your
He's
Honor-
agreed to forgo anything else.
Sorry, Your Honor. Emotional suffering is a type of psychological injury. The defendant, ruling of the court ties
He's
the...
not making a claim, a separate claim for psychological injury in this case.
I believe he is, Your Honor. If you carefully read his brief, what he's saying is he's going to seek damages for both pain and suffering, including emotional suffering. So when a plaintiff seeks damages for emotional suffering, the forensic expert for the defendant needs to take into account the evidence concerning the impact on his lifestyle. Otherwise, the defendant has his hands tied behind his back and has no way to defend it. Emotional injury involves the impact on lifestyle. I'd like to just address the second error. The second error is the court made no finding on culpability. And therefore, as a matter of law, the court cannot issue a sanction on spoliation. The law is clear that...
But you don't have to, somebody can, in this case, the destruction of evidence didn't turn on whether or not on liability. It turned on the fact that there were tapes that were clearly relevant, and your clients unilaterally decided that it was okay to destroy those. That doesn't turn on whether or not there's liability.
Respectfully, the case law is clear, applying the New York Court of Appeals and this court's law. There must be a finding of culpability in order to award a sanction.
I'm going to interrupt because you are right, that there does have to be a finding of culpability to make a claim for spoliation. And the law is also clear that negligence is enough. You don't have to show anything more than that. And the court below was somewhat confusing in terms of exactly what determination that court was making. But what prevents us, as the appellate court, from looking at the record and determining whether there is an adequate record of, at a minimum, negligence here, since there's no dispute that the tapes were substantially destroyed, and make a determination as to whether or not that was an adequate sanction?
This court does have the ability to comb the record. That, as you said, Your Honor, the court below did not make a clear ruling on culpability. There's no question this court has the ability to address that issue.
Why shouldn't we find on this record that there was negligence?
Because there was no negligence. May I answer your question
May I
very
answer
quickly? This was one of dozens of accidents that occur in my client's business. This injury, despite my friend's analysis, was not a serious injury. The plaintiff...
You don't consider degloving of an arm to be serious?
Your Honor, it was not. The plaintiff did not spend a night in the hospital. He was treated. He went on with his vacation.
I guess the photographs don't show anything.
The photographs are ugly, but the reality is that there was no reason to believe that there would be a lawsuit. This is just not that type of case. It was you know, the plaintiff went on to continue his vacation. The allegations about...
You have more time on rebuttal. Thank you.
Thank you.
But you can further address that.
Good afternoon, Your Honors, and may it please the court. My name is Kristen Janaros for the plaintiff respondent.
I wondered if I could start by asking, your adversary indicates that in your brief, you do say you're going to seek emotional damage. So how can you separate out, and how could a jury separate the pain and suffering from the emotional damages to figure out what should be produced and what should not be produced?
At first, I'd like to clarify that our brief states that plaintiff is only seeking damages for pain and suffering. We don't specifically delineate that that's going to be emotional in nature, but even if it was, the way the court defined in McDougall, the Court of Appeals defined the suffering element of pain and suffering as the emotional response to the sensation of pain. It still ties to the plaintiff's underlying feeling of pain from the injury to his right arm. So he can say, you know, I mean, he didn't testify to this, but I feel depressed or sad when my arm hurts. I'm not sure.
But he can't say, I feel depressed because I can't play as much baseball, or I can't do this or that.
Correct, Your Honor. And he's been precluded from asserting that by the trial court. And he's been very clear in this litigation. He's expressly disclaiming any allegation of the loss of the ability to enjoy life or partake in recreational activities. He's solely seeking recovery for the pain and suffering sustained to his right arm. And that is analytically distinct from the issue of loss of enjoyment of life. The way to challenge the plaintiff's claim of pain and suffering in this case is by, for example, performing an IME and calling the physician to the stand who can testify to his examination of the plaintiff, whether he believes the plaintiff's complaints are subjective or objective in nature, not by proving that he's lost the ability to enjoy life. He's not making that claim here, and that's very different and discrete from pain and suffering itself. Just to briefly move on to the spoliation issue, Your
Let me ask you a
Honors.
question about that specifically, which is that there was some confusion as to what finding the trial court was or was not making about negligence, which clearly is required to make a spoliation finding. How do you want to address that?
I think
How
that
would you address that?
I think that the motion court's wording was perhaps inartfully worded, but I think the intent of what the court was trying to find is very clear. The case law basically demonstrates that an adverse inference charge is the sanction imposed when the culpable state of mind is negligence. And here—
Where is the negligence here that we should find based on?
Sure. I think that the fact that this was spoliated at the very least negligently is readily apparent from the fact that the defendant here had, I think there's no question, they anticipated the likelihood of litigation after this gruesome and unusual accident.
Weren't the police called to the scene of the accident?
Police-
He was taken to the hospital, whether he stayed for the
Correct.
night or not, he was taken to the
He
hospital.
was. An ambulance was called. The police themselves took him to the hospital, and he did have a overnight admission.
That's what I thought. He stayed there.
He did. I don't think that's honestly relevant, Your Honors, but to correct the record, he did stay for 2 nights. And the fact that this footage was negligently spoliated, I think is apparent from the fact that this footage was not preserved, even though they knew, this was a very gruesome and unusual accident. Why aren't we saving it? There was an explicit instruction from management which told the employees, collect and obtain the footage for what they deemed a, quote, extremely urgent matter. And finally, there's an admission in a marketing video from the Top View defendant on YouTube, which specifically acknowledges that the footage from the dash cam is extremely significant and important to the company for the purposes of an accident. And despite that, we don't have this footage saved. It's nowhere to be found. It was highly relevant to the plaintiff's claims of negligence in this matter, that the defendant's bus driver negligently operated his vehicle, failed to see what there was to be seen, including this traffic board which lacerated the plaintiff. And based on that, we can at the very least determine that the defendant negligently spoliated this, and that warrants an adverse inference sanction in this case.
Would you address the incident report?
Sure. I think that the testimony of Mr. Poole and Mr. Abdelgawad clearly indicates that Mr. Poole did fill out an incident report. He testified, I didn't send out any emails or text messages about this incident. Abdelgawad testified that the incident forms are on every bus. Mr. Poole should have filled one of these out after the accident, and that he couldn't explain why it couldn't be found. There was no testimony from the defendant or an affidavit stating, well, the incident report was actually just like an email or a statement to—
Did he change his testimony as to whether he had filled one out or not?
He, I think, was equivocal on whether he could remember if he did, but he ultimately twice testified that he did create an incident report.
My recollection of the record is that Mr. Poole, the driver, indicated that he had spoken with witnesses to the accident. Is there any record outside of the incident report, a possible incident report, as to what witnesses' names or addresses were?
No, Your Honors, we made a discovery request for that information, and Top View's response was that they were not in possession of any kind of witness statements or identification for any of the witnesses on the bus that day because they mostly paid by cash. So there's no record for the plaintiff to track down any of these witnesses. So there should also be a spoliation sanction imposed for that as well.
Thank you very much.
When an expert evaluates emotional damages, a forensic expert takes into account the impact on life. That's how you measure the effect of pain on emotion. To separate the two out is
Well,
just
wouldn't
not
that
appropriate.
Wouldn't that, I mean, if you get an expert report that does that, wouldn't that give rise to a motion in limine to raise before the trial court? Now that it's been clear that he's waived any claims as to enjoyment of life?
It might, but Your Honor, our expert has his hands tied behind his back because he doesn't have the forensic evidence he needs in discovery to conduct that analysis. And the issue here is, how does a defendant defend against a claim that the pain caused this emotional response in an injury like this? In terms of spoliation, the lost footage was really not relevant. And
How do we know that? And why is it up to your client to determine that?
Well,
I mean, that seems to me a
we know that
very serious problem that.
Sorry, Your Honor.
The
We know that because the footage that was saved showed the accident, and the complaint is being made about the loss of footage from the front of the bus. However, the accident occurred when the side of the bus hit the city sign.
So, counsel,
So the front.
counsel, so in the United States, we all drive on the left side, right? And the bus driver testified that.
The right side.
No, I mean of the car, not of the road. Oh my goodness, no, no. But we drive on the left side of the car. So I believe, if I recall correctly, that the bus driver testified that the arm of the plaintiff was outside of the bus.
Correct.
Nonetheless, the footage that would have shown what the driver was seeing is not here anymore because it was destroyed by your people. Isn't that dispositive as to sanctions?
No, I don't believe so, Your Honor. The driver, while he did not fill out a formal incident report, he issued a statement on the day of the accident that made clear what he saw and when he saw it. And the footage would not have really been dispositive because of the nature.
That's what you say, but if there's surveillance footage, then it should be preserved. And we, I believe, had testimony from your operations manager that he was aware that litigation was a real possibility here. So the rule is that you have to preserve the surveillance videos, not the ones you think might be helpful. I don't know what they show. You don't know what they show. None of us are ever going to know what they show because they don't exist anymore. But I think it's your responsibility to at least preserve them.
Well, that may be true, but the lower court made no finding on the issue of
But
culpability.
counsel, the reason why I raised driving on the left, in the bus on the left side, is because this passenger was on the right side of the bus and he was on top. So I, for example, would be most curious to know whether the footage showed that this man who's driving the bus could actually see what was going on the top of the bus on the right side. And maybe the surveillance footage would indicate.
It might have, Your Honor, and I acknowledge that. But the issue here is culpability. There was no finding of culpability. There was an extensive record about what happened and why it happened.
We've addressed that, and we're familiar with the briefs and the record, so thank you. Smith versus City of New York.
Good afternoon, Your Honors. Julie Steiner for the appellant. Supreme Court erred in finding that the plaintiff raised an issue of fact. This court's most recent decision from about 2 weeks ago in Rabbage is quite dispositive because it reaffirmed the long-standing precedent that a plaintiff has the burden to establish with non-speculative evidence that the city affirmatively created a defect that immediately affirmatively created the defect through an act of negligence that immediately resulted in that dangerous condition, and plaintiff did not do that here.
Since Yarborough, right?
And it's been gone since Yarborough.
Is there anything, I'm sorry, just I'm not familiar with Rabbage, is there anything new or different in that, or just a reaffirmation of the?
It's just an absolute reaffirmation of Yarborough and its prodigy.
And do you have a citation to that?
To the Rabbage case? Yes. I can give you the Lexus site yet because it's 2024. New York App Div Lexus 2603. It just came down May 9th, 2024. Unfortunately, none of you were on the panel. So plaintiff did not do that because he only,
The court held, just out of curiosity, the court held in that case that it was an immediately dangerous condition?
yes, so the court, we had lost, excuse me, the city had lost below and the court reversed the denial of summary judgment to the city, finding that in opposition, plaintiff failed to raise a question of fact that the city affirmatively created the defect through an act of negligence. So
Was
it's,
it a factually similar case to this in terms, I mean, that's the real issue, because you have to look at each case on its facts and whether or not it was an immediately dangerous condition. So are you mentioning it because it was just restating the legal principles, or because you think it's factually analogous?
I think it's both, but it's very important to know that plaintiff here is only pointing to speculative evidence as to an affirmative creation. So I wanted to point out that this court has reaffirmed what plaintiff's burden is.
Okay, so why in this particular case, what did the trial court err in finding it was an immediately dangerous?
So interestingly, the trial court actually conceded that the evidence that it was relying on was in fact speculative, and yet somehow denied the city summary judgment. The incident here occurred at a crosswalk at 2nd Avenue and 55th. There are 5 repair orders in the record that could be in that area. All of them were closed, and our witness testified that closed meant that it was repaired
And the latest one
resolved.
was 5 months before the accident?
So yes, Your Honor, the most recent one was 5 months before the accident in April of 2017. That's not an intersection, that's the roadway number 1.
So it's undisputed that that was not the same location as where?
It should be undisputed that it's not the same location. The court, however, erred in relying on Mr. Hall's testimony, who was the work supervisor that day. He had no independent recollection of what work he did that day, and the only evidence in the record from that work order is that it was a pothole in front of 360 East 55th Street, which is undisputedly close to 1st Avenue, not near 2nd Avenue, which is the intersection where the plaintiff fell.
So counsel, I diagrammed to the best of my ability where the accidents took place, and I saw the proximity, and I also read the testimony that when there were defects that were visible to the, I'm going to say contractor, would that be fair?
Work crews, yeah.
Or work crews, they would be repaired on site. If there's a repair that's out, does the record show anything indicating whether repairs outside of the ambit of a work order resulted in some kind of additional paperwork, like an annex or something to the work order?
There is absolutely nothing in the record that shows that any additional work other than that which was listed on that repair order was repaired. And so for the Supreme Court's ruling, by relying on his speculation or on his speculative testimony that they would go out and look at the particular site, but then also look generally, and if there was a defect, they would repair it if they could access it. The Supreme Court's ruling allows a jury to impermissibly speculate several things. It's layer upon layer. One, that the city performed repairs in the crosswalk where she fell, that it was done in a negligent manner, that it was the specific defect on which she fell, and that defect, or that repair, I should say, didn't gradually arise over time in that 5-month period. Speculation upon speculation upon speculation, and that is insufficient to raise a tribal issue of fact. So for that reason, given that there is no non-speculative evidence in this case, this court should reverse and grant summary judgment to the city. Thank you.
Good afternoon, Your Honors. May it please the court. Counsel just cited to Ravitch that was just recently.
Let's put Ravitch aside because we haven't read it, and
Sure.
really each case is fact-specific.
Well, that
Under the circumstances of this case, where it's undisputed that any repair that was done, the last time repair was done 5 months earlier, and not even in the location where the accident occurred, how have you created evidence, since it is your burden, that there was something the city did that created an immediately dangerous condition?
So it's twofold. So Ronald Hall testified that, and he was actually there that day, that he would.
The day 5 months earlier?
Day 5 months earlier, on April 17th, that he would review where the location was at first, But then they would look at the whole block and make repairs to any defect. They wouldn't, if they make repairs to any defect that's not listed, they wouldn't take photographs of that defect.
Counsel, just listening to that sounds so speculative to me. How can we possibly know, based on that testimony, whether there was or was not a defect where this plaintiff actually fell, that they actually did something to that immediately resulted in a dangerous condition? Because we don't even know, based on his testimony, whether they did or did not do any other repairs other than the one they were sent there to do. How would that not be speculation that any verdict would be based on?
Well, I think that it's a question for the jury. If the supervisor who's there that day
Doesn't there
says,
have to be more than speculation for the jury to get that question?
well, I think it is more than speculation when the supervisor of the repair crew states that they repair all the time whole blocks and the defect. That would allow the city to make repairs.
But that would be, but he didn't say we repair the whole block and we saw something in this corner, but we didn't deal with it. I mean, there's nothing in his statement that suggests that there was anything wrong on that day 5 months before the accident.
Correct, because they don't keep records and they don't take photos of defects that they repair, so the city can make.
That's where
But
my
that doesn't-
question,
I'm sorry, go ahead.
that's where my question was going to go. Same as what I asked your adversary, which is, are there any records at any point in time that indicate anything that falls outside of a given work order?
No, and that's the problem, that Ronald Hall testified that they would just fix those holes, but they wouldn't take photographs of that. They would just.
So how is plaintiff going to prove that that's where they felt that they did the work there? If that, I mean, what else are we going to get if there are no records?
We are relying on testimony of Ronald Hall to state that when they repair defects on a block, they look at the block, and he did say
And
specifically.
that maybe there was one there, and that's maybe where they fell?
Which would create an issue of fact, but he did say specifically crosswalks. They would definitely repair defects in a crosswalk, even if it wasn't listed as the
A lot
proper
of jumps for
defect.
the jury you want the jury to make in this case.
Counsel, also, doesn't it need to be immediately, like the negligence immediately
Right.
results in a dangerous condition?
It does, and the case law, Rabich and Yarborough, they talk about a gradual decline. So when a pothole is repaired and it has wear and tear or environmental conditions, that it then depresses. And that's what happened in Yarborough. That's what happened in Rabich. The pothole depressed and there was a hole. So that repair was improper. In this case, it's a raised patch. So that is immediately apparent because it didn't change with weather. It didn't change over time. It was a raised patch that was placed there by somebody. I mean, this was done 5 months. There was repair work done in that area 5 months prior. You know, the city's
We have no idea who did it.
well,
Other
that's
than that
the jury.
maybe the city was maybe doing a work a block away and maybe didn't see it.
Seems like an issue of fact, Your Honor.
Okay. Thank you.
Thank you.
Two small things, Your Honors, to respond to your question about what Mr. Hall might have put in a record.
Why isn't it an issue of fact?
It's not an issue of fact because, as you pointed out, it is absolutely, utterly speculation upon speculation upon speculation. Maybe they found another defect somewhere in the area. Maybe they did the defect. And then even if there were a defect that the city did repair somewhere near there, she has to prove that it was the defect over which she fell and that the defect that was repaired, how it was repaired, wasn't done properly and immediately resulted. We have Mr. Hall's testimony as to how the repairs are done. And plaintiff then, in response, had to come forward with an expert or something, some other evidence to show that that wasn't done. He specifically said, at the time that we repair, everything is level. That is undisputed. That is at pages, well, I don't have the page offhand, but it is in my brief, Your Honors. He specifically explained how these repairs are done. That is undisputed, that at the time he left the site, it was level, and that's it. He needs to come forward with something else to show that that was, something was immediate, and there is none of that here.
Thank you.
One thing, Your Honor, personally, After 25 years in this law department's appeals division, I am hanging up my appellate hat. And so this is my last argument before you. I've been before several of you before, and I want to thank you very much. It has been an honor and a privilege.
Good luck.
Good luck to you.
Not retiring, just hanging up that part of my.
You don't want to argue before us anymore?
I might appear for an interim application. Thank you, Your Honor.
Thanks.
Petty versus Bronx neighborhood? Go ahead. You should go in front of the microphone.
Good afternoon. May it please the court, my name is Lorraine Petty, pro se. I apologize, this is not my wheelhouse, but I'm just here because I received 2 grants. I was approved for 2 grants that were not fulfilled due to the fact that Bronx NHS evaded and colluded with their contractor to evade all safety precautions, all safety provisions required by HPD. In exchange for those emergency repairs, Bronx NHS received a 10-year UCC lien with a continuation stipulation. The crux of my complaint has been consistent. Bronx negated their fiduciary duty of care for the emergency repairs and should not be entitled to a 10-year security interest. The attorney attempts to convince the court that Bronx's mere filing of a UCC does not create a fiduciary duty. Bronx has the first position to seize Appellate's home or personal assets and fixtures for any default. Bronx exerted overwhelming operational control over Appellant and owes a fiduciary duty of care. Every duty was done with malice. Bronx is an adverse 10-year UCC security interest holder. Bronx's substantial involvement of malice and forethought is cleverly orchestrated and involves deception. I apologize, I'm not a public speaker.
No problem.
And their misrepresentation is to ensure that Appellate's grants are not fulfilled as prescribed, and Appellant's home remains in distress, so that the grant converts to a loan with forever indebtedness. Bronx, in conclusion with their recommended contract, avoided the required safety precautions, as I said before, from the HPD scope of work. Now, they have a UCC letter on page 160 in the Record of Appeals. And on that UCC, it says, upon issuance of a commitment by Bronx. Well, what commitment? If you look in the project loan agreement, it was a bait and switch, because it's no longer a grant, it's a loan. And for the egregious terms of this project loan agreement, they're entitled to security interest in my premises, all my personal property and fixtures, wherever located, whether now owed by borrower or in existence, hereafter acquired or created. It goes on and on and on. These are egregious entitlements. And they are earning this 10-year security interest without performance, without the expected performance. Now, I had structural concrete laid down in my home. And since they did not abide by the HPD scope of work, and as Oscar Morella falsely claims, the general requirements are not applicable to plaintiff grants. He says grants. But according to the buildings department, concrete placed at any building under construction in New York City is required to be tested to ensure it meets the structural design requirements of the project. Concrete testing must be performed by a licensed contract testing lab, and this is why they avoided the HPD scope of work, because they didn't want to have the intervention of the buildings department. They denied me the inspection because they wanted my home to be in distress to expose me to default. A job cannot be signed off unless all applicable concrete requirements have been met. The contractor evaded his promises in his proposed estimate. Everything that Bronx did was malicious. They gave me a disclaimer for their recommended contractors, then stalled me. I couldn't use my own choice of contractors. They then prevented their recommended contractor from attending a closing. I had no mutual assent. I had no chance to finalize my proposed agreement. I had no say into what was going to happen to my home. And now I'm sitting in a house that's unstable because there's cracks, the doors don't close, because they did not get the concrete tested, they did not follow HPD's protocols. I have 2 liens on my house. I couldn't even leverage my home if I needed to get the structural work done because they have my hands tied with the liens.
Okay, you can have some time on rebuttal, thank you, if you want it.
May it please the court, Anthony Maturo for the respondent. Before we even get to the facts that the appellant is addressing, we need to know exactly what her claims are, and that's the basis of this appeal. The trial court has dismissed the appellant's complaint on the basis that there was no particularity stated for any cause of action. Now, I anticipate the court's going to ask me, well, we addressed numerous issues with respect to fraud, misrepresentation, unjust enrichment in our motion papers, but that's because the respondent had to engineer and assume and make a leap to guess at what the claims are. I would anticipate that a trial court would not dismiss the complaint just by citing 3211 and saying there's no cause of action, but that we had to come up with some allegation. Now, clearly the appellant is unhappy with the results of her contract, but Brooklyn was just an intermediary. She's making allegations of fraud, misrepresentation.
I'm sorry, who's Brooklyn?
Bronx, sorry, Bronx neighborhood.
Don't mix up Brooklyn and the Bronx.
I'm sorry. I must apologize. This is my first appearance. I'm usually in the second department. For years of practicing, almost 30 years, I heard how beautiful this place is, and it truly is. I was happy I finally got here. It's on my bucket list, and now I'm here.
So I have questions for you, of course. So the Bronx Neighborhood Housing Services is a not-for-profit, right?
Correct.
And its aim is to assist low-income homeowners to obtain funding so that they can obtain dollars on an emergency basis to make qualified repairs through project help, right?
Correct.
So to what extent, and I don't know if I'm going outside of the record, but I know that there's disclaimers as to, for example, the choice of contractor is within the purview of the homeowner, and you make no representations as to the quality of their work.
No, there's the only requirement is that the contractor...
But to the extent that someone makes complaints that the work is not being done properly, what process, if any, did you follow? No inspectors, from what the record says, were sent, and the money was released. Half of the money was released in what one could call stage 1 of the process.
Well, the requirement for Bronx is that there must be a licensed contractor.
That's easy.
Right, and then there was inspections halfway through, and then at the completion of work, that the work was completed. This issue that the court's asking, goes beyond whether or not there was a cause of action stated. The court is to take the facts pled.
But you've heard of amended complaints. I mean, the question is there anything there? So.
Well, no, there is nothing there other than that it was done to the satisfaction of the appellant homeowner, and then the payment was released.
So when you're in the, BNHS is not, at what point did the inspection take place in the first stage? Before the money was paid or after the money was paid?
Before the money is paid.
Before the money was paid. And there was the work cleared inspection?
To the satisfaction of the homeowner, and then the money is released.
What did the inspector say? Is there a report in the record?
There is no report in the record.
I saw what the report was for the second.
Excuse me?
I saw the report with respect to the second stage.
Right.
But with respect to the first stage,
I'm not aware of any report of the first stage.
So we don't know the scope of the inspection in the first instance.
No, not in the record. But
And
that
we
again
don't,
goes.
we don't know if the money was released pursuant to a favorable or an unfavorable report. Is that correct?
That's correct.
Thank you. You have a minute, and rebuttal.
Thank you. It's false.
Madam,
They denied me the inspection at the 50% benchmark. They denied me the 50% benchmark. And when she did come, it was at the 75%. The contractor had already arrived at my home for the second phase of work. Payment was done, even though I complained to them. There is a report. The report for the inspector demonstrated my complaint that I made early in June. And then in October, when she finally came for that report to see the destruction and the skirted work, she stated exactly what I stated in June and July, that the water well was not done, and that is on the scope of work, and he paid them for that. Even though I communicated with him, they made no remedy to help me, neither the contractor nor Bronx NHS, and I looked to them for guidance. I truly thought they were there for as advocacy group for the community, but they were really trying to rip me off from my home and all my personal assets.
Thank you.
It was a switch and bait with the agreement.
Thank you.
Thank you.
Parella Weinberg Partners versus Kramer.
Good afternoon, Your Honors. May it please the Court, Maureen Shaw from Quinn Emanuel for the appellants. Now, I'm very mindful and appreciative of this
Could you
Court's...
speak right into the mic?
Yes, I'm sorry, it sounds very loud to me. I guess not to you.
Better now.
I just wanted to start by saying I'm very mindful and appreciative of this Court's limited role in reviewing decisions from the trial court and the vast breadth of your docket, and I want to assure Your Honors that we were mindful of that in bringing on this appeal what are three very narrow, straightforward issues in a case that has dozens more issues that are set for trial. And I want to start with the one that's a pure issue of law that can be decided on a de novo review by Your Honor, and that is the enforceability as a matter of law of the covenant not to solicit employees. And I want to read to Your Honors what the covenant says. It prohibits employees, says they may not hire or solicit, recruit, induce, entice, influence, or encourage any firm employee, regardless of location.
Interrupt for a second. If you were just talking about a facial challenge as opposed to how it's been enforced, then why isn't our law about blue lining sufficient to deal with that? That if there is any portion of it that's considered unenforceable, the law allows for it to be rewritten.
Glad you asked that question, Your Honor. I'd like to point out first that the language here is so overbroad that my adversary doesn't even try and defend it in the briefs. They go straight to blue penciling. And so blue penciling.
Which is allowed in New York.
It is allowed, but highly disfavored, and there are clear legal standards that are enunciated in cases like BDO and Oliver Wyman that they have to make a showing for why it would be appropriate on a case-specific basis that specifically examines the conduct and motivation of the employer that would justify blue penciling in this case. They didn't even attempt to make that showing here, much less have made it. And so there is no cause for blue penciling, and blue penciling isn't the answer, because imagine, Your Honors, I want to give you an example. I mean, the language is so overbroad here. Imagine two employees, and this is not our case, but this is the reason for a facial challenge and the reason for the disfavor of easy blue penciling, right? Imagine two employees sit on the same floor, but they don't work together substantively. One walks by the other and says, hey, you know, I'm thinking of retiring at the end of the month. I have a nice cabin upstate. The other says, retirement really sounds nice. You know, I would do it if I were you. That would be covered by the language of this contract. And it's really no answer to say.
You're making such a broad example. I mean, there are standards that need to be met before you have a valid clause as to how it impacts the business. So those claims are not going to survive whether or not there's a valid facial challenge or not. It's not going to survive on a more particularized challenge. So I'm not sure how that really completely supports why there can't be some editing of it.
Because, Your
the
Honor,
facts and circumstances of the particular case.
The whole point of striking down covenants instead of blue penciling is to not give employers a free pass to use the most chilling and deterrent language possible in all of their contracts. And employees will conform their behavior accordingly, and many won't challenge it. And if and when challenged, the employer can just say, oh, disregard all those other words, you can pare it back to solicit, and that'll suffice here. That's not the public policy of New York, and it shouldn't be encouraged. This is a very sophisticated employer who, by the way, isn't defending the language of this covenant because they don't even use it anymore. They know it's not enforceable, and they're trying to just say, don't worry, Your Honor,
Is that in the record?
I
They
believe
don't
so,
use it
Your Honor.
anymore?
I believe it is. I don't have a citation for Your Honor. We can write in about that if you're interested. But the point being, I think blue penciling here, it is an option available. It is one that is disfavored and requires a clear legal showing, and they haven't made it.
Since we only have a limited amount of time
Yes.
here, I understand that's your primary argument that you want to focus on. Do you want to address the issue of the court's partial grant of summary judgment on the actual BDO test as applied?
Could you specify what you mean, Your
The
Honor?
court partially granted summary judgment to the plaintiff.
Yes.
On the solicitation clause as applied in this case. Do you want to
Yes.
address that grant?
Yes, thank you, Your
I
Honor.
assume that's your second
It
part
is.
of your appeal challenging it. So since you've had a lot of argument time on the first issue, before we run out of time, I thought you might want to
Thank
address
you, Your Honor. And I do want to reserve time for the other two issues very briefly, but in response to Your
And
Honor's
you have
question.
to do it within.
Yes.
That's why. Good.
Thank you. It is also unenforceable and applied, and I think the trial court came to the opposite conclusion by overlooking what is clear bedrock New York law under BDO and other cases, that an employer has no protectable legitimate interest in protecting against relationships that employee came into the firm with. And that's the case here as applied. It's undisputed in the record that the defendants, my clients, all worked together for years and even decades in the industry before they came to Parella Weinberg. They came to Parella Weinberg in
What about
order.
the argument, though, that they, not only that they bought the goodwill, but that over time they helped support those relationships over the period that they were.
There's no substantial legitimate evidence of that. The only thing that the trial court cites in the record is expense receipts for not even all of the defendants. I think just two of the defendants that total something like $1,000 worth of meals and taxis. I mean, the idea that those paying for a few meals and taxis over the course of years was a substantial contribution to maintaining a multi-million-dollar client relationship that had been formed decades before my clients came to Parella Weinberg, frankly, does not meet muster under the case law standards. And that is why we say, as a matter of law, as applied here to my clients, who undisputedly worked together for decades and brought significant client relationships with them that they built for decades ahead of time, pointing to a few taxis and a few lunches, really doesn't meet the legal standard for meaningful contribution to that relationship.
A little time left.
Thank
you want
you.
to quickly address the non-solicitation of clients?
Yes, and this is one where we think truly there is no undisputed evidence in the record that would prevent summary judgment on this claim. And I would note that summary judgment on this claim would drastically narrow the issues for trial, the witnesses that are needed to be called, and really promote judicial efficiency here. And it's well worth it. If you look in the record, I want to focus on Monsanto, which is the biggest client at issue here. Now, they note two things to raise the specter of a dispute of fact. That one of my clients contacted a principal over there to have lunch after he was fired. No testimony about what, nothing else. Contacted him to have lunch. And that Monsanto later hired my clients on a different engagement that PWP didn't have. That, frankly, does not raise any inference of a material dispute of fact on this client when the undisputed evidence from the mouth of the client principal himself, under oath in deposition and in affidavit, said, neither Mr. Kramer nor Ducera solicited Monsanto for this assignment.
Okay, you're going to have time on rebuttal. Thank you.
Good afternoon, Your Honors. Christopher Bellier from Gibson Dunn on behalf of the plaintiffs, respondents. Justice Kearns, nice to see you again. We were here two months ago on a different appeal of the labor law claim they had in front of you. And Ms. Shaw, on this case, Ms. Shaw started off by saying that they tried to bring narrow issues here on this appeal. That's completely wrong. What they're doing here, because we're advancing their fees, is they're throwing darts at the wall. So we were here 2 months ago on the labor law claim. You denied that appeal. they've now filed a motion for leave to argue in front of the Court of Appeals. They actually brought that same motion for leave in 2017, the exact same one. It's frivolous. So now what are they doing? They've raised 3 new issues and said, okay, here we go, the non-solicit should not be enforced. Why? Because this is a textbook solicitation case. The facts are egregious against defendants. So they're saying, oh, your court, you should find that the non-solicit does not apply here. There are 2 analytical frameworks here that apply. There's the Cantor-Fitzgerald framework, which you don't even engage in a reasonableness review under Cantor-Fitzgerald. And that is the case here. There's a forfeiture provision for cause, for their equity, in the partnership agreement. There is also a forfeiture provision in their deferred compensation. It is textbook law, that is Delaware Supreme Court from January of this year, that if there is a forfeiture for competition provision, the reasonableness inquiry does not apply. Why is that? Because reasonableness is not how you typically look at a contract, right? In the real world, you look at a contract and apply the terms of the contract. This is a partnership agreement among very, very sophisticated parties.
Counsel, I'd like you to address specifically whether or not the trial court erred in denying summary judgment to defendants with regard to the Monsanto claim. Could you address that, please?
Sure, I'm happy to pivot to client solicitation if that's what you like. So yes, this is textbook factual issues. They have pages upon pages in their brief about he said this, she said that.
What's the actual, I want to go back after we're done to the first issue, but what's the factual basis on the Monsanto claim that best supports your claim that there's a factual issue that there was improper solicitation? I know there's a lot of evidence generally, but what actually supports your argument that improper solicitation happened that violated the clause?
Sure, Mr. Kramer was terminated for cause in February of 2015. Within weeks, he's on garden leave, by the way. He's still being paid by PWP under certain obligations. He's reaching out to Monsanto without telling PWP, using his personal email and
By
whatnot.
reaching out, you mean like having lunch?
Well, yeah, he's reaching out to them to talk to them.
Right,
And then
okay, so what concrete evidence is there that he solicited them?
he's reaching out to them. He's been a business colleague of theirs. The minute he incorporates Ducera Partners the day after his garden leave on May 18th, so his garden leave ends May 17th, May 18th he incorporates Ducera. He already has in July, he has an engagement with Monsanto, which is his first client engagement. So he got that, must have gotten that during that time, the solicitation. So he has gone out to them during the garden leave and has wooed them. I think there's an email about him going to a Rangers game with one of them from some of the people from Monsanto's, taking them out.
So you're saying by having any contact at all with them? he
No, I'm
violated-
not saying.
And that's what it sounds, that's what I'm hearing, that because he contacted them and spoke to them in any way, shape, or form.
No, but it's a question of credibility. It's the same thing as the solicitation, the employee solicitation, right? There's a question of credibility of Mr. Kramer's testimony on that, and the GC, the former GC of Monsanto, who I deposed, right, who's Mr. Kramer's friend. There's credibility issues as to that testimony, as to what was said and not said.
Could you juxtapose?
That's textbook for trial.
Counsel, could you juxtapose the differences or similarities between Monsanto and Fidelity? Fidelity never left the plaintiff, and there were 2 contacts, 2 phone calls apparently, informing Fidelity that Mr. Kramer was leaving and with his colleagues, and that did happen, 2 months afterwards. So, but they never left. So
that's correct. On Fidelity, they didn't leave, but it shows his pattern of violating the client non-solicit.
Is there a claim?
Well, there's a claim for client solicitation, right? And so we have set forth a number of clients, and you're right, there are no damages on that one.
I was just going to ask you that.
I concede you on that one. On Monsanto, there are damages. Alpha, this is another example, right? They say, oh, Alpha, there's a different group of creditors we went after. Well, there was a spreadsheet before they left of all the restructuring clients.
Well, I was going to ask, there's on 3667 and 3668 of the record, there's a list of certain clients. Were those clients that they had brought in with them? Who were those clients, and how should they be treated differently or not differently?
That's a pipeline of clients at that time, so in February. So that's what the restructuring group was working on at the time. So, it's also a fallacy to say, Mike Kramer walked into Parella Weinberg and all of a sudden he kept all his clients from before, and Parella Weinberg didn't give him any help him with any resources or expenses. They make this new argument in in their brief that all of a sudden he came, they didn't help him. There's nothing to support that. And actually, if you look at their brief, they don't actually cite to anything in the record for that. They just say, Mr. Kramer did this all on his own. That would be like if I worked at a 10-person law firm. I went to Gibson Dunn with my clients, and I said, Gibson Dunn's platform of 2,000 lawyers is not helping me expand my client relationships. Mike Kramer had a family office in Connecticut, Kramer Capital, which its assets were acquired by Parella Weinberg. He went to Parella Weinberg for 8 years, and they're saying that Parella Weinberg did not help him develop any clients or any relationships. Monsanto's a great example of that.
I'm going to interrupt.
Tons of M&A work.
I'm going to interrupt for a second because we only have a minute left, and I want to go back to the first issue, which is that the court actually granted partial summary judgment to you on the first element of BDO with the personnel solicitation. I want you to address why it was proper as opposed to opposing counsel's argument that at a minimum there's a factual question as to that issue and as to whether there were pre-existing relationships and there wasn't really any solicitation of personnel.
Well, there's a question of solicitation. The question, what the court found...
Solicitation that was not relationships that already pre-existed, so that they didn't do anything improper with it.
But that's not the law. So I think this is an oh, by the way...
But the law is no greater than that is required for the protection of the legitimate...
Yeah,
so if the employer has no legitimate interest because they were already pre-existing relationships, that would support not granting summary judgment to you. So why was it appropriate for the court to decide that as a matter of law, you were entitled to summary judgment on that particular issue?
Because Mike Kramer, and this is, I'm going to take Vice Chancellor Parsons' language, he called this an oh, by the way claim. In other words, you want to retrade on something. Mike Kramer, when he joined Parella Weinberg, and this is in the record, he entered in the framework agreement, and he had a side letter, which is R121 and 120 to 123. When they acquired Kramer Capital, PWP actually gave him the option, because PWP was at that time incorporating itself and drafting the partnership agreement at that time. There's this side letter, and it says, Mike Kramer, if you don't like our restrictive covenants, you can withdraw from the partnership. And in fact, if you...
How does that pertain to the issue we're talking about now?
Because it pertains to the reasonableness of the restrictive covenants. Mike Kramer was given that option. He then chose to sign on to it. Not only that, but 1405, which is the provision right after the non-solicit, says that he agrees that
there's a separate issue as to whether or not he agreed to the covenant and whether or not the covenant has actually been violated based on the actions in this case.
Of course it's been violated. I mean, it's
that's what I'm asking you. Why, as a matter of law, was it appropriate for the court to find that there was a violation?
I don't think the court found that it was a violation. The court found...
Well, found one element was violated.
No, it said that the test of reasonableness was satisfied. And then they said, we're going to have a trial on whether there was solicitation.
And that's my question. Why was that appropriate for the court as a matter of law to find that the test of reasonableness was satisfied?
Because all the elements are met. There was a legitimate interest here in keeping the client goodwill or safeguarding it, the client relationships. That's the first element. There is no undue burden or undue hardship here on Mike Kramer. For one of the reasons I just articulated, and on top of that...
I was only asking about the first element. That's the second. So thank you.
Okay, thank you.
Right, I'm going to talk fast. Your Honor, in response to your last question, it absolutely was inappropriate on this record for the trial court to have granted partial summary judgment in favor of the respondents on the issue of whether this covenant can be enforceable as applied here, given the pre-existing client relationships.
Well, what about his argument that your client voluntarily agreed to the provisions of this non-solicitation, which clearly provided that this kind of taking of other people at the firm was not permissible once they joined?
Every covenant that comes before your honors was agreed to. So that's not the standard. This was in long hundreds of page document partnership agreements. And it's, every case that I said comes before your honors has been agreed to. So whether or not it's agreed to is not the predicate test. Now here, he only pointed to one client who he said there was a side letter for. I have 3 other clients here. One of them wasn't even a partner in the firm, didn't have equity in the firm, was forced to sign on to this covenant as a salaried employee. So if nothing else, this court should remand for a determination after trial as to whether this covenant really meets the first prong of BDO as applied here, given the evidence of pre-existing client relationships. Your Honor, I want to go to your question about Fidelity and Monsanto. There's absolutely zero record evidence in this case that either were solicited. Number one, Fidelity didn't leave, as you noted, no damages. They don't even have a claim for Fidelity in this case, a complete sideshow that they're bringing in because they don't have other evidence. Number two, I want to make it clear, no client they've identified here left Parella Weinberg to go to my clients. They went to third-party firms. We didn't take any of their clients. Now,
Didn't Monsanto want to work with plaintiff? Didn't they want to do a deal with Kramer and plaintiff?
Caesars did. So let me get to that. Monsanto, who said, by the way, we were at Parella because of Mike Kramer. Okay, we would not have gone to Parella if Mike Kramer wasn't there. Full stop. Monsanto took its existing business at Parella to a third-party firm, not to Mike Kramer. They only went to Mike Kramer later for a new engagement that arose later that Parella never had. There is no there. Caesars, as Your Honor points out, Caesars asked Parella if they could work out a deal with Mike Kramer to keep the existing team together and advise them. They tried to work it out, and they couldn't, so Caesars went to a third-party firm. Our clients didn't get the business. Thank you, Your Honors.
Downey versus Giles.
Good afternoon, Your Honors. My name is Jason Steinberg, and I represent the appellant, Alfonso Downey. The Allstate is basically arguing that if a relative is living at the property without the named insured, that relative is automatically not covered.
I don't think that their primary argument is that the named insured has to be reside in the premises, or the insurance policy has no validity. That's their claim, and your client doesn't live there, right?
That's correct. My client.
So how do you get around the fact that she doesn't live there, and how do you claim that the policy is valid notwithstanding that?
Well, because she's not the only named defendant in the case. We're talking about Kareem.
But she's not, there's no other named insured.
Kareem Giles is a named, he is an insured person under the policy.
But he's not a named insured.
That doesn't matter. It doesn't matter. The insured person, records 106, okay? The definition of an insured person means you, that means the named insured, and, remember, you and if a resident of your household, any relative.
Right, that
right
means
there.
that he would be covered if she were covered, but she's not covered because she's not a resident.
She's not covered, okay, but Kareem Giles is covered as the relative. He gets the benefit of the protection. And if I can explain. He is an insured person because he's a relative that lives in the household. Household is not defined. What they're doing is they're equating the term household with dwelling. Dwelling is the place you have to live. There's a definition for dwelling. And I can turn at the record 108. The definition of dwelling means 1, 2, or 4 family building structure identified as the insured property on the policy declaration where you reside. Notice how
the you refers to the named insured, which is Miss Downey or Mr. Downey, who does not reside there. So it's not an insured premises. That's the problem.
It is an insured premises. I'll tell you, because even under the definition of insured premises, it's still an insured premises, because insured premises means a residence premises, which does not necessarily mean a dwelling, and I'll get to that in a second. Insured premises is the residence premises and under Section 2 only, any premises used by an insured person being the relative, in connection with the residence premises. So a relative is covered. She does not have to live there. And then let's go further than that. Residence premises, record 107, residence premises means the dwelling, comma, and then it says other structures and land. Why not just say dwelling? Dwelling is the place you have to reside. Other structures, that means other structures where a relative lives.
Counsel,
they don't define that. It's ambiguous.
Are you familiar with our decision from 2016 in State Farm versus Guzman, which had similar terms in its homeowner's policy, and we found that it was undisputed that the named insured under the homeowner's policy did not reside at the subject premises, and therefore, under the policy, the subject premises was not covered in a similar kind of case. How do you address that case?
If I recall correctly, in the State Farm case, it didn't involve the question of whether coverage was for a relative living at the premises. And it was undisputed in that case. I mean, I understand that the relationship, meaning that the named insured is not living there. I get that part. But here we're talking about the coverage for the relative, Kareem Giles. And there are exceptions in this policy for relatives. The residence premises is defined as a dwelling. That's the definition. That's the key word, dwelling, because that's where the policy says you have to live there. It is the dwelling where you live. But then it says other structures. That accounts.
You have to get dwelling covered, and a dwelling means a 1, 2, 3, or 4 family building structure where you reside. She doesn't reside, and Ms. Downey's the only person who is the you. So therefore, this is not the dwelling.
It's not considered a dwelling because she's not living there. It's not
Right,
under that
exactly.
definition.
So once that's not a dwelling, then the policy doesn't cover anything that happens there.
Well, residence premises also includes other structures. It says other structures and land. So it's not just the dwelling itself.
So, counsel, you would agree that if you look at the policy, that where you reside, you is in boldface all over the place, right? That where you reside is a phrase that's repeated in different sections of the policy, and the emphasis is on where you reside.
Yes, but
is that important or not?
I'm sorry?
Is that important?
Where you reside is only defined actually in two places in the policy. The definition of where you reside is considered the dwelling, and that's it. There's no other definition of it. So it begs the question as to why are they saying that a relative that resides in your house, or why not just say your dwelling? Then you would make the argument, well, that means you must live with your relative to get the coverage.
But
I'm sorry, go ahead.
No, I was going to say household, I think in common parlance, means the people who live with you.
Well, the law says ambiguities must be resolved against.
That doesn't sound like an ambiguity. Household is like we all be together, right?
Well, they have household, they have structure, they have multiple words in here, but they do take note to define the word dwelling. So why not do that for household? To me, that is an ambiguity that should be resolved. Okay. Thank you.
Good afternoon. May it please the court. My name is Karen Berberich, and I'm here on behalf of Allstate Insurance Company. This is actually a very simple coverage issue. Because the named insured on the policy does not reside at the accident location, the insured location, there is no coverage. It's not a residence premises. And because of that, all of the arguments that are being raised by plaintiff, and this is plaintiff's counsel, this isn't the insured. So his client is not one of the named insureds on the policy. The named insureds are.
I was just going to ask, how would you address the argument that because the policy also covers structures in addition to dwelling, that there would be coverage?
Other structures actually is in the policy for fences or other things on your property. There are other structures that are located on your property that there's also coverage for. The definitions are definitions that are applicable to both first-party coverage and third-party coverage. So that definition is applicable to if your fence gets blown away in a hurricane. Other structures are going to be covered. That's what it means under the policy. It's not what counsel respectfully was arguing.
So, counsel, with respect to homeowners policy, homeowners policy is presumably a policy for a person who owns a home and lives in it?
That is correct. You have to live in the home in order to have a homeowner's policy.
Otherwise, you have to get a different kind of policy, a rental policy or whatever,
Correct.
even if it's a family member.
Correct. Because the language in the policy requires you to live there. If you don't live there, it's not a homeowner's policy. That's not the right policy.
Which language in it do you claim shows that you must live there?
It is the definition of residence premises. So it's number 7. It's in the record on page 107. And that is the requirement. It means the dwelling and other structures and land located at the policy address.
And residence premises includes the dwelling, and dwelling is defined as where you reside, is that right?
Dwelling is the structure, that is correct. That's where you reside. You have to reside, the named insured has to reside in the dwelling on the land.
So there's a piggyback, so to speak, between one and the other, one provision and the other?
So the basis of our motion to dismiss was the applicability of 2 exclusions. And if you look at the definitions, the highlighted terms in those exclusions, because it's a residence premises, that's a requirement for it to be an insured premises. So if it's not an insured premises, there's no coverage. The policy doesn't provide coverage for bodily injury that arises out of a premises that is not an insured premises. In order for it to be an insured premises, it has to be the residence premises where you reside, and or there's some other definitions that are inapplicable. My colleague believes Section 6 applies, but again, it has to be in connection with the residence premises.
So your adversary says the key here is that the son is an insured person and that you're missing the point.
The son is not an insured person because in order to be an insured person, he is a relative, but he doesn't reside in the same household as the named insured. It's very clear in the record that the named insured resides at one location and the son resides at another location. In order to be an insured person, you have to live together under one roof in the same households, and they clearly do not. So, and even if he was an insured person, there still would not be coverage, because it does not qualify as an insured premises, regardless of whether he's an insured person. And there's also the business exclusion. There's also, because the policy does not provide coverage for bodily injury arising out of the business activity of an insured person, the rental of property, by definition, is a business. And so because this property was rented, it is a business, and it arises out of that rental.
Are you referring to the first and second levels, or just the second level where the older person lives?
So it is a 2-family home, and the second level is rented. So as long as it's rented, it doesn't have to all be rented. The whole house doesn't have to be rented. But because there was a rental of property at that location, and she was receiving rent, there's no question about that.
And she was not living at the premises?
And she was not living at the premises. That is correct.
That part, that's what excludes her from the exception?
That is correct. That is correct. Yes.
Thank you.
The exception is for residence premises, and she doesn't live there, so the exception doesn't apply.
Thank you.
That doesn't address that under residence premises is not just dwelling. It's dwelling and other structures. Building structure is defined in the policy, a structure with walls and a roof. Why are we making a distinction between structures and dwellings if they only intended to cover you where you live there?
So isn't a tool shed a structure like that?
I'm sorry?
Tool sheds. Don't tool sheds have walls and a roof?
They do, but I don't know if tool shed is defined here. I'm not
just
sure that that's
asking when
intended to be included.
I'm just saying that the word structures.
Right, adopting that, assuming it is tool shed, that would mean the tool shed, and that is covered under the policy. She doesn't live in the tool shed.
Not.
She doesn't live in the tool shed. So, but again, resident premises, and that defeats the whole business argument, because residence premises is not the only. In other words, if it's other structures that are rented, it has to be more than 2 people. So it's not a business if you rent to one person. The policy specifically says it's not a business if you rent to one person, right? And that includes resident premises, which also includes other structures.
We don't get into whether or not it's a business until it's determined that it's a residence of the person, of the named insured, and that's the problem you have.
I think what really comes down to is, can a parent get an insurance policy for their house and let their children live there without living with them? So, and I think all the fact that you have all that language in there covering these other structures makes a distinction between the place where you have to live and this structure or household where your child lives. Yeah. Okay.
Indulge.
Flintlock Construction versus HPH Services.
Good afternoon, Your Honors. My name is Anthony Raynone for the Appellant HPH Services and Shalin Haddad. Full disclosure, I know I have the uphill battle here today. This was a bench trial, 2 days worth. But I do believe on the whole, the court got this one wrong below. First and foremost, there was a standing issue. This was a...
Counsel, the standing issue was addressed by a prior decision, right?
Those were pretrial motions that even the adversary concedes. The law of the case does not apply to this.
Okay.
This is for you to call here. And
What was wrong with that pretrial determination? Why isn't that the correct determination? There's undisputed that they claim they paid the suppliers.
I'm happy to
that
answer
you were
that.
required to play.
Absolutely.
Why isn't that enough to create standing?
Rarely do I have a legislature that has written so clearly on something here. And the legislature's clear. When you acquire a trust claim by assignment, it's no longer a trust claim. That's the lien law, section 71(3)(c).
But isn't the whole point here and the reasoning of the court below that it's not based on an assignment, that it's based on subrogation? And that subrogation's different than assignment?
They are two different things. I do believe
Aren't they making their standing claim based on subrogation rather than assignment?
They are certainly making that claim, and I will tell you
Did
why.
the court accept it below?
They certainly did at trial, and I believe it was wrong because this was not a subrogation. Subrogation in New York is very clear. It's where you, by compulsion, pay the debt of another, and there is a great case on why this is not subrogation here. It's a Second Department case cited with approval by the First Department. The Second Department case is called Broadway Houston Mac Development v. Cole, 71 AD 3rd, 937. That's 2010. Was cited by the First Department in 2017. But the facts of that Second Department case were almost virtually identical here. Instead of the GC paying the subs, it was the owner who paid the subs. And he then sued, claiming to have the trust claim because he had paid the subs. And the Second Department, affirming summary judgment below by the trial court, said these weren't voluntary. These were voluntary payments. The owner, and in this case the GC here, they had no obligation to pay these subs.
Well, if they wanted the work done, I mean, if they wanted to get the work completed, they were going to have to pay the people. They paid your clients, and they did not pay the material people.
But that's not a legal obligation and compulsion to pay for them. And in that instance, Your Honor, yes, there were liens filed on the project. There was a dispute, obviously.
Let me ask you, we talked a little bit about law of the case, but
Yes.
there was a determination made that standing did exist based on subrogation, and your client did not appeal that determination. So since your client didn't appeal that determination, which held that subrogation is sufficient basis for standing, why isn't it law of the case?
I would say, first and foremost, law of the case does not apply to the appellate division. But second,
but
I know what you're asking. I want to
reading
answer it.
below.
I want to answer it. There was a pre-answer motion to my recollection, and there was a summary judgment motion to my recollection.
But what does that matter? I mean, it's the same case where a judge in Supreme Court made a decision and said that there was standing. Nobody appealed that. So whether it's pre-answer, post-answer, I don't see what the difference is.
And it's, in addition, it's the same legal analysis. It's whether or not that kind of subrogation claim is sufficient to allow standing.
I agree with you. It's the same legal analysis. I do believe that it was preserved at trial, and we are appealing the trial judgment by the court. That's the answer to the question. I understand what you're asking. I have the record I was given, and that's the straight answer to the question, Your Honors, as my adversary knows.
Could you address the loss of books and records by your client?
Yes, we believe the trial judge got that wrong. The witness testified there was Superstorm Sandy. His office was in Newark, New Jersey, which was hit significantly by it. That was the testimony. She did not believe him. In fact, I think at one point...
And isn't a fairly major part of our jurisprudence that we defer to the trial judge on credibility findings, and hers certainly was strongly stated in this case. How would we, on what possible basis could we reject that?
I understand, and I will answer that, Your Honor. I believe.
Because I note that most of the cases you cited for why we should disregard it were third department cases. And while I respect the third department, we're not required to follow them.
Yep. I will explain why I think the trial court got this wrong and why this court should vacate it. The trial judge, when you read the two-day transcript,
Let you
did I
just
finish
that
answering? Or?
statement.
I'm sorry.
Let you finish that statement.
I will. She had predetermined the case, in my opinion, when you read the two-day transcript. I've out of time, but I would address more if you'd like me to.
You'll have time rebuttal. Thank you.
Okay, thank you.
Good afternoon. May it please the court. Larry Hollander for plaintiff respondent appellant. I'll skip based on your questions and go right to it. Subrogation. The distinction on the case that counsel just cited is that an owner has a different obligation than a general contractor under the lien law. An owner, if he terminates a GC, there's no trust fund because no monies are owed. A GC, however, when liens are filed, like they were in this case, by every single one of the depositors, can't get paid unless they bonded. Plus, they had to buy the equipment anyway. So they were compelled to purchase it. And there was two standing decisions. Judge Friedman did it, God knows how many years ago. In this case, will be moved by order to show cause to try to attach, which was denied. But she ruled standing. So twice, two lower court judges have ruled on that. In any event, the standing issue, Lien Law 71 specifically allows a subrogee to assert a claim, and more importantly, appellant has misidentified who the trustee is under the statute. The trustee is not Flintlock. It's not the GC. It's the subcontractor, appellant. He's the one who receives the money. So the statute doesn't even apply to that issue regarding the anti-assignment provisions.
I'm actually going to ask you to address something completely different from the assignment, which is the Dolphin claim in particular.
Dolphin is easy. You want to go to Dolphin? I shall address.
I do want to go to Dolphin.
I shall address Dolphin.
I'd love to see a real dolphin in the courtroom. That's not going to happen.
It's like a hanging curveball, Your Honor. R-716, Haddad Affidavit.
I'm sorry, say that again?
Haddad Affidavit, R-716 of the record. The affidavit that acknowledges not only forwarding Dolphin's invoice requesting a 50% deposit, but every single other deposit that the lower court determined. R-70 and R-73 of the record.
What about Weiss's admission in cross-examination in particular, that he admitted in cross-examination the absence of any request for payment by HPH to plaintiff related to the Dolphin equipment and requisition aid?
On that line item.
What?
On that line item. The requisition number 8, which was at issue in the trial, the line item breakdown of each item is scope, plumbing, this, that, whatever it is.
But it was a line item worth $111,000.
I didn't hear you, Your Honor.
It was a line item that ultimately was worth $111,000. So my question is why we shouldn't.
It's a twist.
Back on on my colleague's question, why shouldn't we reduce the judgment by that amount?
Because it's a twist argument. The lower court based its decision on requisition number 8. If you look at R-70 and 73 of the record, the Weiss affidavit on direct testimony itemizes every single line item in which payment was made to HPH and adds it up, and it's the exact amount that the lower court awarded. So,
What about the admission and cross-examination? What do we do with that in particular?
but you have to understand the admission and cross-examination. The admission was, what supplies did Dolphin provide? Weiss answered. They said, well, there's nothing requisitioned in requisition number 8 under that line item. Is that correct? The answer is yes. But it was requisitioned in the other line items. Again, the 471 trial verdict is right off of R-70 to 73, which is a meticulous itemization of every single line item in which a deposit was given. And that supported the lower court's decision of the $471,000 number. So when I
Was that
said,
brought out on redirect?
I'm sorry, Your Honor?
Was that brought out on redirect? Because it seems to me that his testimony on cross is pretty damning.
Again, I disagree because
Was there any redirect on that issue?
I believe that the redirect was on R70 and R73 on the direct affidavit. We did it, I believe, perhaps in the post-trial brief. Maybe I did it in the post-trial brief.
Counsel, I'd like
I don't
to ask
remember.
you a question about the escrow account and the monies that were placed in Mr. Haddad's wife's escrow account and thereafter released to one of his companies. Would you speak to that, please?
Well, sure. I think the lower court cited that as the last reason why personal liability should be held on Mr. Haddad individually. Because bear in mind that appellant notes that if you have personal involvement in this, and the trial court held that he did everything, I think the lower court's comment, the last comment on the escrow account, was he even brought his wife into this by putting money in his escrow account. So not only did he pay every bill, not only did he do every single thing that occurred in this case, but then he brought his family in. That's what I believe is the import of the lower court's statement on that.
Thank you. You have time for rebuttal.
My cross, I'll go.
What?
My cross appeal?
Yes, I gave you a minute to
Now or
rebut.
later?
Oh, we can have it after. In case he says something you're anxious to respond to.
Thank you, Your Honors. You asked the question, this goes to Your Honor's question about why should we step in here. You raised the dolphin issue, you've covered that. You add on top of that, sorry about that, I now know your argument. You add on top of that the business records issue. The New York CPLR has long been clear on how you can admit business records.
Well, but these records were documents produced by your client.
But producing a client in my possession, Your
So
Honor.
you produced invoices, gave them to HPH, and you're now saying those weren't your business records? They were just miscellaneous documents? They weren't
No.
business records?
No, I'm saying
I mean,
they're-
I don't understand why they're not an admission against interest, given that you produced them and expected them to pay based on them.
they relied virtually their entire case on those invoices and those amounts. They're not HPH business records. Those were produced by, written by third parties. They're clearly out-of-court statements. All they had to do was lay a foundation and call the right witnesses. It was a Zoom trial, Your Honor.
Didn't you lay the foundation?
Say that, I'm sorry?
Did you lay the foundation?
No, it wasn't my client's burden, Your Honor.
Thank you.
Thank you.
I'm sorry, did you want to ask a question?
Well, I was just curious your response to counsel's argument that Haddad had actually asked for 50% of the amounts due to Dolphin.
I believe he denied that, but to me, Your Honor, it wouldn't matter, and I'll tell you why. It was unequivocal for Mr. Weiss. Mr. Haddad never billed never billed Flintlock for the Dolphin invoice. That was the difference with that one, why it was such a big deal, that it was undisputed at trial. It could not have been part of things because even Mr. Weiss admitted Mr. Haddad never billed for the Dolphin invoice.
Thank you.
Thank you.
On your comment about damning evidence, Your Honor, 2 seconds. Again, I refer you to R716. Anything in the record that supports this determination, the reason I called it a twist is because they're trying to parse out a line item where a deposit was not paid, and they're trying to separate the invoices from the fact that the line item paid it. On the cross appeal, if I may, I suggest to the court that an interesting issue was posed before you because there's no First Department case law on punitive damages vis-a-vis lien law 79A and lien law 77. I'll state ahead of time that I believe this trial record, and in falsus uno and falsus omnibus, you can tell the tone of the trial judge in this case, not too happy. So, what do you do with someone who, using street vernacular, sandbagged my client into paying him close to $500,000 and now is walking away with just no punitive damages? We suggest that this court follow to Albany, to the Third Department, as cited in our brief, that under lien law 77, where any remedy, other remedy that the court may give, which has been interpreted by this
You want
court.
punitive damages in every case.
I'm sorry?
You want punitive
No,
damages in every
actually, I
case.
don't. I don't. But I'm following the statute, Your Honor, and there is a very big distinction between 79A and 77.
In every
Okay?
77 case you want it.
I want you to go to Albany, not to Brooklyn. So I would
far, though.
I would respectfully suggest that the train with the view of the Hudson is a much better way for this court to go. But seriously, I think this department now has an opportunity to address what is a very important issue, particularly to us in the construction industry. I thank you for your time.
Jasi versus FSP.
May it please the court, Your Honors. My name is Carol Finocchio. I'm appellate counsel to third-party defendant appellant Newland Interiors Corporation. Please forgive me, I have a little bit of a cold today. It's our position that the court should reverse the order that granted the plaintiff summary judgment under labor law, section 241, subdivision 6. It is speculative for the court to conclude in any way, or for a jury to conclude, I should say. The lower court did not find my client negligent as a matter of law. The lower court said it was unclear at page 27 of its decision. We're a third-party defendant. Our position is that the plaintiff himself, it would be pure speculation to show that this pin was left over from Newland's demolition, and that's...
Speculation, isn't there, putting aside the issue of negligence, isn't there a tremendous amount of evidence in the record that does support that the pin was left by your client, pin nail was left by your client, based on the totality of all the circumstances and the tractor, and that your client was doing the demolition work, that there were pins there with the tractors were removed, et cetera, et cetera?
Your Honor, I would respectfully disagree, and the reason that I say that is at the outset, plaintiff didn't show us what room he tripped in. What he did was he waited a week until after the accident. Then he brought in his supervisor, Mr. Sheridan from Eurotech.
You're skipping that he told his coworker about this at the time.
He told his coworker that he hurt his knee. And then what happened was they didn't find the pin because plaintiff apparently had removed it at the time of the accident.
But there were some other pins there, and he said this is a fair and accurate picture of what it looked like, and it was kind of covered in a lot of dust, looked kind of like part of the concrete had been there for a long time.
Your Honor, what he did is he went 1 or 2 or 3 rooms away and found another pin. Now, based upon the photographs in the record at page 10008 to 1011, if you look at that, no one can say, the plaintiff himself couldn't really say that it's from a former wall track location, the pin on which he tripped. He said the floor was dirty, there was sheetrock dust everywhere. So we think it's speculation for anyone to...
That's what they were removing all, they were, I think, gutting those spaces to prepare for a law firm to come in. And you could see by looking at the pictures, and everyone who looked at that said, well, there had been walls there, and there were sort of the tracks from the walls were removed. This pin must have not gotten removed.
Well, Your Honor, I would respectfully disagree because some of the people that looked at the pictures couldn't really tell. Mr. Maloney couldn't really tell. And then Mr. Sala, who was our witness, in looking at the photographs, he couldn't really tell. And then
Mr. Salah testified that it was very likely that this type of nail would have been removed during the demolition of the drywall track.
But, Your Honor, he also testified that looking at these photographs, which are all we don't have any pictures of the actual location where this happened. He also testified that looking at these photographs, he can't tell whether this nail was from an existing wall track that was never removed or whether it's a new nail. And if you do look at the photographs...
So that just means he didn't rebut the showing. It doesn't mean that he established anything favorable to him. Neither Mr. Salek didn't claim that he'd inspected, and Mr. Vizuet, your other witness, said he'd never even been to the 16th floor. So I don't, assuming that we find that the plaintiff made an adequate showing on summary judgment, how did you rebut that?
Your Honor, this is the problem. We were gone for a whole month, and Structure Tone inspected the premises at the conclusion of our work and never stated that we should come back for any reason. So it's very hard to rebut anything because it's speculation that it was left from us. But it would be hard because...
I would think that you would have been able to produce somebody who was there who would have said, I inspected before we left, and this is the situation. You didn't produce anyone like that. Excuse me. You didn't produce anyone like that who actually had that level of familiarity with the 16th floor, right?
Your Honor, Mr. Sala testified that the general procedure there...
Right, but that's not the same thing as saying that he knew that he had personally inspected the 16th floor after you finished your work.
Your Honor, the testimony that we did produce showed that Maloney of Structure Tone and his people, his foremen, would inspect the work at the conclusion of every night after Structure Tone did their work, and that if there was a pin remaining behind, they would remove it. So what happened was we were supposed to leave it in broom finished condition. Structure Tone inspected it, we left, and then a month later the accident happened. So I see my time is up, Your Honor. I will, unless there are other questions, I'll rest on my brief.
Thank you.
Thank you.
Good afternoon. Allison Snyder with Barry McTiernan and more for the defendant respondent appellants. I just wanted to start off with the contractual indemnity issue, if I can. Hopefully that's going to be a quick issue. The court below fundamentally misconstrued what type of indemnity provision this was.
Let me ask you about that, because it does not have a negligence trigger. I mean, that's the first thing you look at when you look at indemnification clause. Does it or does it not have a negligence trigger? And this one doesn't have one. In the absence of a negligence trigger, which is not present here, you have to show that it arises out of. Why isn't there a claim that it arises out of your client's work?
Well, I have to say, so we represent Structure Tone and the building.
Oh, actually, this is. I'm giving you the other side.
Right.
Yeah, I'm giving you the argument for you.
Well,
you're arguing that it does arise out of the work of both defendants.
I have to say, I'm a little flummoxed because well, I absolutely, I'm not quite sure what provision the lower court was looking at, but the
neither of them have a negligence provision, and you're arguing you don't have to show negligence, and as to one, there's adequate proof that it was their nail, and as to the other, it was their employee.
Well, not even that, if I can, Your Honor. Okay. Just with respect to Eurotech, the employer, I have to say I'm hard pressed to think of a situation where you have an employer who is admittedly, the employee was admittedly performing the work they were retained to do, where that doesn't constitute an act. I mean, they were literally at the premises doing the work, so that's an act. So, it arose out of an act of the work they were retained to perform. If you read Eurotech's brief, they make it seem as if we are seeking a summary judgment on a negligence claim. That's obviously not right. But with respect to Newland, it's not so much that we have to prove that it was the specific nail. If you buy into that argument, you're basically taking their position that there has to be some proof that it was caused by their work, and that's not what it is. It's literally, did it arise out of the work that they were retained to perform? And yeah, you're correct, Mr. Sala.
Well, the project arose out of Eurotech, and it didn't arise out of the work they performed.
Well, it arose out of.
We'd have to find that it was their work. So then you have to find. Don't you have to find it was their nail?
No. If I can, Mr. Vizuet, I hope I'm pronouncing his name right, the foreman, he was very clear about what the nature of the demolition work was, that they had to basically he said that they had to leave the floor absolutely clear. If anyone sees a nail protruding like that from the floor, it had to be removed. It said, I have to make sure that the floor is absolutely clean and flat. And that was how they had to leave the premises. And Mr. Sala, the owner, he said when he visited the site every day, that's exactly the type of condition he would look for. And he was asked, is there a requirement that the floors had to be left clear of nails, from the floor tracks? And he said yes, that's something he would look for. And when he was asked, when he was shown a photograph of the nail, is this the type of nail that had to be removed from the floor during demolition of a drywall track? That's when he said very likely. That's at 8:09. So they're saying that this is the exact condition that the work that they were retained to perform. And by all accounts, this was exactly the type of condition that they were supposed to remove. And so the question is, did it arise out of their contracted work? Yes, they were contracted to remove it. And whether it appeared a week later, a month later, whether...
If it arose, you're saying that even if it arose out of Eurotech's work and that Eurotech was doing work, then it would still be? I mean, that,
No,
otherwise it'd have to show it's their...
No, it can be concurrent conditions. Now, with respect to Eurotech, it doesn't matter what the condition was. Literally, it arose out of the work they were contracted to perform. That's the act. So it doesn't matter what the condition was, but the condition matters with respect to Newland because that was the work they were retained to perform.
That's what I'm asking you.
Yes.
So it does matter.
Well, it matters with respect to Newland because, I mean, let me just say, I think in their position, when to move for summary judgment to dismiss contractual indemnity, it would be as if you were a contractor who was retained to install windows and the plaintiff is claiming he tripped on a nail. You're able to say, well, yes, it didn't arise out of the work I was retained to perform. His accident had nothing to do with windows. But that's not what we have here. There's no dispute that this exact condition was what they were retained to demolish. So if you get into whether or not it was caused by their work, that's a different situation.
I'm saying it arose out of their work as opposed to Eurotech's work.
And there's no
If it arose
dispute.
out of Eurotech's work, then let me ask you then: Are you seeking conditional indemnification or absolute indemnification?
Well, I think absolute is with respect to the owners. Nobody's disputing that their liability is purely.
Has everybody been broken down in the briefs as to which ones you're seeking?
We
That's
actually.
a real question.
Oh, I'm sorry. I apologize. I think now. I mean, I think it's clear that it's conditional. I don't think that it really. I don't think
Sorry,
it necessarily.
you're talking so quick. I'm having trouble hearing.
I don't know that it necessarily matters. I think that it's fairly clear that it's at least with respect to the owners. But what we argue in our
You haven't
briefs.
broken it down though. In terms
We
of
argue that conditional is warranted. And if I can just briefly touch on, let me just quickly argue with respect to the 241-6 claim. The one thing I do want to point out is that the plaintiff does not dispute that this pin is consistent with the work. The one thing that his employer was asked was, does Eurotech...
You're talking about integral to the work?
Well, yes.
That's a term of art. Is that what you're referring to?
Yes, except that the way that, as I understand it, the regulation specifically says consistent with, and if it's consistent with the work, then it's that's what triggers the integral to the integral defense. And what the plaintiff and his employer say is that this is the exact type of nail that they use in erecting the walls. So, I mean, even though it's a little bit different, I know that normally the situation is whether or not it was, work that was performed by the plaintiff and his coworkers, but literally, there is testimony from our client who said, well, even if we can't prove that Newland was the one who actually shot this into the concrete, it can arise when you're erecting walls.
Thank you. You have time, rebuttal, to further develop that.
Thank you so much.
Good afternoon, Your Honors. May it please the Court, Irina Kravchenko, I represent third-party defendant responding Eurotech on this appeal. It is Eurotech's contention that the Supreme Court correctly denied the owner and general contractor's motion for summary judgment on the contractual indemnification.
Let me ask you the question I mistakenly asked her, which is, since there is no negligence trigger in the indemnification and the plaintiff is clearly an employee of Eurotech, why doesn't it arise out of and trigger indemnification under that provision?
Your Honor, it is Eurotech's position that it had to still arise, have something to do with the work.
I'm sorry, what?
It had to still arise, meaning having something to do with the work. And in this case, there is a tribal issue.
Well, he was an employee doing the work that he was supposed to be doing. How does it not arise out of his work?
Your Honor, I'll rest on my brief with respect to that issue, other than to say that there is a question of fact as to whether this was Newland's steel pin. However, the primary point with respect to contractual indemnity is that the movements did not establish their freedom from fault, which is the prerequisite before we even get to the arise.
That's why it's conditional. They don't have to establish, that's the whole idea of conditional indemnification, that it's conditional on them being free from fault and a determination will be made.
Yes, Your Honor, with respect to that, I would like to point the court to its recent decision in Diaz versus P&K Contracting, Inc., 22483rd 405 in 2024. There, the court rejected or declined to consider the conditional indemnity claim because, quote, the movement does not specifically request a conditional summary judgment order. In this case, while on appeal, Structured Tone attempted to sort of request conditional summary judgment. This argument was not raised below. The word conditional does not appear anywhere in the moving papers, and that argument is not preserved. So the request was not timely.
Well, let me ask you something, because the rule normally is that even if it's a new issue on appeal, if it's apparent from the face of the record, it can be resolved on the record, and there's no factual dispute about it, the court can address it. So what on the face of this record would prevent the court from addressing the issue of a request for conditional indemnification?
Your Honor, given the fact that the movements never actually established or fully breathed the lack of negligence in conjunction with failing to ask for conditional indemnity, that's why this issue should not be before the court, because they actually never even attempted to show their freedom from fault below. Essentially, the entire papers were an inversion of the burden of proof. The movements asserted that it has not been established that they had constructive notice. So they're ever evolving a factual argument with respect to that, combined with the fact that they did not seek contractual indemnity below. Oh, I'm sorry, conditional contractual indemnity below. And I will just briefly add that Eurotech also opposes reversal with respect to new land, based on all the conflicts in the testimony as to whether this steel pin belonged to it. I'd like to point out with respect to that, in addition to any confusion about the photographs and plaintiff identifying the pin, which of course is a question of fact in and of itself, plaintiff actually described the location of the pin, which was in the middle of the new room and where the old partitioning used to have been. So that adds to the question of fact. And with respect to Newland's position that, Structured Tone was inspecting the work and let them go, Structured Tone's witness actually expressly testified that he found other pins left behind by Newland, and he actually also indicated that the floors are very large and it's easy to miss any item. So essentially, Structured Tone admitted that it could have missed something when it was inspecting, raising questions of fact as to Newland's fault.
Thank you.
Thank you.
Good afternoon. May it please the court. Just want to open up with, being grateful that Justice Gonzalez, I see you in person. Last time I argued, you were on a screen. So in person is always better.
Thank you.
Record evidence shows that each party admits 7 different ways that this was a pin that had been left over from Newland's demolition work. Plaintiff testified that when they removed the track from the old framing, they didn't remove the nails, 279, 280 of the record. The accident report prepared by Eurotech says, plaintiff tripped on a steel pin sticking out of the floor that was an existing steel pin, and that steel pin constituted a tripping hazard. I'm quoting, existing pin nail not removed from the floor. And then there's a section at page 1445 of the record. How can future incidents be prevented? The report states, remove steel pins and nails from the floor. Defendant General Contractor Structured Tone, Peter Maloney, confirmed that during the walkthrough, following the completed work, he observed that Newland failed to remove more than 1 pin from the metal track on the floor in separate rooms, and he directed Structured Tone laborers to pull them up with a crowbar. Eurotech's Bernard Sheridan confirmed that the subject pin was from an old track that should have been removed as part of Newland's demolition work, since Eurotech's new drywall installation work was on a different line than where they were putting on, where the old
Was there any problem that the actual pin that he fell on and the actual place that he fell on, he couldn't go back there? I mean, he could go back there maybe, but there was no pin there, so he had to use a different pin. Did that raise any issues of fact?
Not at all, because Structured Tone actually asked their laborers to remove the pin right after the accident. So there was no.
So they
pin
went to a
left
different
anymore.
room where there were still pins, and wasn't he able to recognize it and say that this was an accurate reflection of what the pin looked like, even though this was not the exact pin he fell on?
Exactly. And there were other pins in that room and in other rooms as well that were left over. Newland's Mr. Vizuet and Mr. Sala confirmed that Newland was responsible for removing the tracks and the pins, and Structure Tone's 2 laborers were responsible for making sure the floors were clear of obstructions. So to the extent that there was a question earlier that Ms. Snyder indicated, well, there's no evidence that this pin was actually shot down by Newland. It wasn't Newland's responsibility to shoot it down. It was Newland's responsibility to pull it up, and Structure Tone's responsibility to pull it up, and they didn't do so. So our position is that there's no question that 23.1.7E2 applies here. The area was a floor in which plaintiff was working and passing. The leftover pin created a tripping hazard. It was a sharp projection, and it was distinctly jutting out from the rest of the floor surfaces. This is, if it pleases the court, this is the Lennard case. And there's one argument by the appellant that indicates that maybe the court should reconsider Lennard. And our position is Lennard is precedent, and it shouldn't. But the basis from which a request for reconsideration is the Maloney case. And the Maloney case is totally different factually because that was a loose pin that was left, and it wasn't something that was jutting out. So that's a poor representative case that would request for which to request a reconsideration. To the extent that there's a question about whether this was integral to the work, I cite to the Lennard case again. This was a stub up that was connected to the floor. This court held that it wasn't an integral part of the work. Notably in this case, the work was removing the pins, and Newland had left a month before. So it was a totally different job at this point. And if the court wishes to take the subway to Brooklyn, the Second Department agrees that in the Murphy case where there was a stub up as well. And my last point is comparative negligence should be affirmed as well. Thank you.
Your Honor, on behalf of Newland again, a few things. Number one, the contractual indemnity, Structure Tone is not entitled to it. There's an issue as to whether they were at fault, obviously, and as Eurotech points out, they did not ask for conditional contractual indemnity below. I want to make a point to address what you said, Your Honor. There's no evidence, there's no testimony that there were other pins in the same room where plaintiff said he had his accident. Plaintiff went, because there was no pin there, he had removed it after the accident. They went to another room 1 or 2 or 3 rooms away and pulled a pin out. So that's problematic. There's no testimony that there were other pins in the same room. And then one other thing I want to point out, which is interesting. Labor Law Section 241.6, as we know, is absolute liability based upon the negligence of some party at the construction site. This relates to plaintiff's comparative negligence. No one testified that they saw the actual pin before this accident. Eurotech's plaintiff supervisor, he did what they call snapping lines. He set up the job for the plaintiff. He didn't see any pins before this accident. Nobody else testified they saw any pins before this accident, and plaintiff himself didn't see any pins before this accident. So it defies logic that he could get summary judgment finding somebody was negligent when he himself got summary judgment dismissing a comparative fault claim.
Thank you.
Thank you, Your Honors.
Feel better.
Good afternoon. The one thing I did wanted to just respond to is when I was referring to consistent with the work being performed, that's specifically from the regulation. And so that's typically what the issue is. And the reason why Lennard isn't relevant is because the installed door stop wasn't consistent with the plaintiff's work. He was carrying carpet. Here, the pin absolutely is consistent. We have the testimony of Sheridan, Eurotech's foreman, who said they use this type of pins. They had installed the reason why they were installing sheetrock was because they had installed the walls. They had the tracks down. And so Maloney, our superintendent, had said, look, even if you don't know if it had been shot in the concrete, typically what can happen is when you're testing out a gun, you can have leftover pins. So the pin absolutely is consistent with the work. And I have to say, I'm actually defense counsel on the Murphy case. That involved a porter who tripped on an exposed stub up, which again is completely different. We actually do have a carpenter here who was performing work that was consistent with the pin. And if it is a pin that is consistent with the work, it's not a sharp projection under the regulation. You can call it whatever you want, but it's not considered a sharp projection that under the regulation. Thank you.